He grew up here.
Trying to convince Nancy to help. So are we going to drink after or? Getting a tree
Killed a lot of it, but I
So I guess right above where I was sitting, right above my head. Thank you. You're
Okay, everybody, 1:30. Board of County Commissioners are open for regular meeting on July 19th, 2022. County Commissioners, Alvin, Schaaf, Ronnie, Maez, Warren.Brown, County Manager Derek.Woodman, County Attorney Todd Weaver, and Deputy County Clerk, and Recorder Tony Bliss, and Hazel Weaver, our President. Call the meeting to order. We'll start with the Pledge of Allegiance, followed by the moment of silence.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Are there any disclosures or conflicts of interest? Approval of adjustments to the agenda?
Yeah, we can't hear you. I'm sorry. We're having a problem in the back hearing you.
Is this turned up and loud enough? Or
Well, get it closer, and then Alan
Get
too.
closer. Excuse me. A motion to approve the agenda. I second. Got a motion and a second. All those in favor? Aye. Aye. Motion carries. Okay, public comments. When you're recognized, please approach the podium. 3 minutes to address the board. Please state your name and address for the record. And I think what we'll do is on short-term rentals, we'll hold those comments until that comes up in excuse me, agenda. So first up, Candace Jones.
Thank you, Commissioners. I sent this as an email last week to the three of you. I didn't get a reply, so I wanted to read this to Commissioners. Last Thursday, which is Thursday before July 12th, the Pagosa Springs reported on the June 30th meeting of the San Juan Public Health Commission. According to the Sun's report, the Florida County Commissioners have discussed, quote, the legalities of separating from the district, how the public work session on this topic directed their county staff to determine the financial situation and personnel policy of the SJPPH. I scanned the agendas of your work sessions and meetings going back to January. The future of the San Juan Basin Health District appeared on a work session agenda in March 1st, and then a citizen concern on June 21st. I didn't see a topic on the regular agenda of the Commissioners this year. I know Bill Hudson offered a public comment about this topic at your last Commissioners meeting. I see since published a monthly department editorial in the Pagosa Daily Post, starting last Friday. From the Sun's report, it appears the Florida County moved expeditiously toward a decision to withdraw from the public health district. As the Florida County withdraws, dissolution of the public health district will follow, and Archuleta County will face another significant infrastructure issue on top of water, sewer, and landfill limitations. San Juan Basin Public Health consults with and inspects child care facilities to confirm they comply with health and safety requirements. San Juan Basin Public Health requires food safety inspections at restaurants and retail locations. San Juan Basin Public Health provides water quality testing for private wells and is the permitting authority for on-site water treatment, which includes septic systems. This is just a fraction of the public health and environmental services that would have to be replaced by Archuleta County in the absence of the public health district. The Florida County Commissioners have staff working to understand the operations of the public health district so they can plan for the future. What is Archuleta County doing? I don't want to assume the absence of public health from your agendas means you're doing nothing. On the other hand, silence doesn't engender confidence this matter has the county's attention. Public health is complex, so is unwinding a public health district that has operated for decades. Please speak to the public on this issue. Identify the county staff who are tasked to plan a public health strategy for Archuleta County. Inform the public about your own assessment of the financial and personnel policy issues we are facing if, or more realistically when, the public health district dissolves. Thank you for your attention.
Candace, would you state your name and address, please?
Candace Jones, 78 Greenwood Park.
Thank you. And next up is Patricia Byers.
My name is Patricia Byers and I live at 189 Twin Creek Circle. I am also here because I'm very confused and concerned about the future of the public health board in our county. I came to the meeting that happened right after the board of directors or San Juan Basin recommended dissolving and put the matter in your hands and the board of commissioners for Florida. And Commissioner Brown, at that meeting you stated, I am not in favor of dissolving because we can't afford it. So I went and looked at the 2022 budget for the county. I don't know very much about county finances, and we can't afford any additional costs. Our county basically, it says, I quote, is operating under survival techniques. We are barely able to meet our obligations. So the possibility of taking on something additional that's already working makes no sense for anybody. I then went and looked at what we're actually paying now for the services that we're receiving. You guys had a commission that met, an investigative committee, and they gave you the report last December. When I looked at they looked at what the cost each county is contributing, and you divide it by the number of citizens in that county, we are the lowest one. We are getting a rock bottom bargain for our health services right now. So why would we dissolve something and go on to possibly have to pay more money? I then went and looked at, okay, well, what are the services that we're receiving for these rock bottom costs? And I think Director Jolin in March, she's going to report to you guys on the services that Archuleta County citizens are receiving. We are 20% of the San Juan public basic health population, and we are receiving over 20% of the services in every single category. One is as high as 70% of services provided. The only one that was under 20% was child care inspections, and that's because we don't have very many child care facilities in Archuleta County. So we are paying rock bottom prices. We are getting more than our percentages of services for what we're paying. I don't know why you guys aren't doing something. The County Attorney Weaver sometime in the spring in a meeting said that it's very possible there will be a tax increase so we can afford this new health district. How many man hours from the county will be put into figuring how to do it? How many legal fees will we have to pay? You guys aren't saying anything. We don't know what you're doing. We don't know what you're thinking. I request 3 things. First of all, you guys should meet with San Juan Public Health Basin Board of Directors and the staff, and you should try to, whatever happened, try to repair it. The pandemic's over. It's gone. The county health board does so many other things besides go and give this, and they're doing them pretty successfully. Meet with them, talk to them. Commissioner Maez, you said at the meeting that I came to that there was a possibility there was going to be a phone call. Did this phone call ever happen between La Plata and Archuleta? Have a meeting, work out the differences before you take on this huge, expensive, time-consuming task. Secondly, as Candace requested, why isn't somebody investigating what's going to happen? Why aren't you telling us how much it's going to cost us? Why aren't you telling us what's going to happen to these valuable services? All of us use services like we want our restaurants investigated, we want our child care facilities investigated, but it's the lower income people in Archuleta County that really use a lot of the services that most of us don't know about. Are those going to be affected? Are those going to go away? Start telling us what's going to happen if in fact you can't stop Plata County from going to dissolve. And lastly, be transparent and open and tell us what's going on. Tell us why this is having to happen. If it has to happen, tell us. Tell us what it's going to cost us and tell us how it's going to happen. There has been no information that I can see from looking at agendas and from looking at reports. No information has been shared. And I would say lastly, I really like to support my public officials. I know it's a very difficult job to have, but in this particular case, I can't understand what you guys are doing. Thank you.
And the other ones we have for, looks like they're all for short-term rental. We'll hold those until that comes up. So 139, for a recess, regular meeting and convening the board of equalization. I didn't see it. I was looking around for it. Good afternoon, Joanna.
Good afternoon, Commissioners.
No, it's just a report, so there's no testimony. She's just reporting on this. That's not it.
Pursuant to Colorado Revised Statutes 39-8-105, 1 and 2, the assessor shall report to the County Board of Equalization values of assessment for all taxable property and a list of all persons who have appeared before the assessor, and to present their objections or protests of real and personal property and the determination in each case. The 2022 valuation for assessment of all taxable property. Real property valuation as of July 8th, the real property value is $378,843,700 for real property. Personal property is $19,931,090 in assessed value. And then the exempt properties, the assessed value is $398,765 and $790. The attached, I have a list of all the people that appeared in May to appeal their properties. We had 18 properties approved, 6 denied, 1 personal property approved for a total of 25 appeals in the month of May. Some of the other things that I'd like to go over that are, I think, important part of this report is some of the assessed value changes that are being implemented this year, such as the residential rate going from 7.15% down to 6.95%, agricultural 29% down to 26.4%. They've now taken multifamily out of the residential and made its own category so that they could apply a separate assessed value to that, so that's going to be 6.8%. So overall, those categories, because of those assessment rate changes going down, the assessed values are going down, but our oil and gas went up almost $15 million, which helps recuperate some of that assessed value. So I just wanted to point that out and bring that up as well. Any questions? It's a pretty slow year for us. As far as appeals go.
No, just basically appreciate the work that you do, Joanna. I know it's hard when you have to deal with the public and make certain adjustments to help keep them happy and help keep yourself happy, your office happy too as well. But it's a very difficult job that you do, and I really appreciate it.
There's a lot that goes behind the scenes that nobody actually sees.
There is.
Thank you so much, I appreciate that. All right.
143, adjourn the Board of Equalization and convene land use regulation hearing. Now, Bowers, you start up through.
I do. Okay, so today we have some land use regulation changes that are not related to short-term rentals, just so everybody knows. These are about pools and utilities and where they can be placed on properties. The pools, what we were asked to do was look at there was a very limited rule, and this is targeted at protecting small children from falling in a pool and drowning accidentally. The only option in the book prior to this was a 6-foot fence around your pool, and that's the way you protect it. It also didn't really define pools very clearly and didn't allow any sort of protections for hot tubs and other types of pools. So we went through, defined, as well as expanded the options on how you can protect a pool from accidental drowning. And then as far as utilities go, we have had, primarily it's come up with solar panels. People go to install solar panels in their home, and there's an assumption that I should put that in the utility easement at the edge of my property. And that's exactly the opposite of what should be done. Utility easements belong to utility companies, they're for public utilities, and a solar panel is a private utility. It's a utility you're placing for only primarily the use of your home, even though some of the electricity may go back to the net, it's still for your home. So it should not be in that utility easement. So that was confusion that folks had, so I decided to expand what was in the book, which was very limited, to make sure that that was clear for all types of utilities going forward. So that's the nexus of these regulation changes. Would you like me to read through them, or are you satisfied with reading it?
Well, there's the one about the pools.
Uh-huh.
I mean, the state statute is that there's private is exemption from any.
That's not what the state regulation says. The state regulation says they are exempt from all of the stuff about that regulation is primarily about the chemical content of the pool, what kind of pump you have to have, what's the percentage of pump to pump power to the volume of the pool, and all those kinds of things. There's a lot in that regulation that has nothing to do with the fencing. The fencing is not required. We don't have to have regulation for any fencing. The idea that the reason it was in the regulation in the first place, again, was just to prevent accidental drowning. So I think what we've done is we basically made it so all you have to do is have a securable cover on your pool or your hot tub, and you're done. No fencing is required. It's an option. If you want a fence, you can have a fence. If you'd rather just have a cover, then you can just have a cover. So that's, we've created, expanded the options to 3 options instead of just 1. So that's the primary thing with that.
Well, and you live here, you definitely want to cover your hot tub, so.
Oh, yeah.
And all the covers usually have a lock on it anyway.
Right.
If I can ask a question, as I'm reading your proposal, under 3.2.5.2, subsection 1, it reads, any private pool shall meet the same requirements set back as principal or accessory structure, but will not be required a building permit. Structures which accompany a private pool, such as decking, fencing, and storage sheds, may require a building permit in accordance with the adopted code. And further, 2 reads, every private pool must be secured to prevent unsupervised access by children and accidental drowning. To this end, at least one of the following security methods must be used. Public pools must comply with state regulations. A is a pool area that must be enclosed by a fence. If a fence is installed on the ground around the pool or yard, it must be less than 4 feet in height and no larger than 4 inches. All ground fences must have a self-closing latching gate or doors that can be fastened to protect against entry and cannot be chain link fences. As an alternate, pool safety fences at least 18 inches may be installed directly at the edge of an above ground pool with a removable ladder. And I don't see the other options.
B is the other option.
B, a safety cover compliant with, so as an alternate, a pool safety fence of at least 18 inches may be installed directly over
That's the
the edge.
second option technically.
Right.
Technically, there's fencing is one option, and within that there's 2. A ground fence or just a pool, like in the diagram example, that's option, the second fencing option, if you don't want to put it on the ground on the pool.
I guess what I'm getting to is at the end of that, there is not an or, the word or.
Well, it says in the
A
first,
safety cover.
at least one of these methods must be used.
So if what you're saying, if I'm understanding it, that means if I have a pool or a hot tub and it's on private property and I have a cover on it, I don't need to do anything else.
Exactly. As long as that covers the standard, which is the industry standard for cover. So you can't just throw a tarp over it, it has to be a cover. Which is what, if you go to any hot tub store, the ones in town, any of them, this is what they say.
Okay. Because my concern was that I'm not aware of any close call drownings or drownings
Nope, neither.
in Archuleta County in many years.
Nope. So initially, the option was, we'll just take it out.
Right.
And then it was, well, what other options can we offer that are reasonable and easy to achieve, which most people do, like you said, in this town, if you have a hot tub, it probably has a cover on it. If it has a cover on it, it probably meets the standard in most cases.
Okay, I just want to make sure that we're not creating regulation that's overburdensome. If there's not a problem to fix, that we don't fix it.
It's up to you whether we remove it completely or we go with this option and we just ask to present options.
So, I like the state's definition, and I read it a little bit differently than you do.
Well, I'd like Todd's opinion on that, because it says private pools are not subject to these regulations.
Right.
These regulations, the regulation in which those words are written, do not apply to private pools. And if you read it, what I'm putting in here is not from that regulation. This is not about that. That doesn't say private pools are not subject to any regulation. That is not what it says. It says these regulations don't apply to private pools. So I'd like Todd's opinion on that.
Well, Todd's not a commissioner, but I appreciate that. And he's a very bright guy. So, okay, as long as again, we're not overburdening folks to solve a problem that doesn't exist.
Like I said, we can just delete section 3252 altogether. That's an option if you want to, yeah. Just ask to provide more than one option besides the 6-foot fence.
Well, I'm not in favor of the fence in any regard, so.
But it should be an option if somebody has a fence, yeah, we'll just go with that.
I agree, as long as it's not the
And
only.
it had a 6-foot fence around the entire property. You'd be done. But there are a lot of properties that don't have fencing at all, so it's just a question of whether we care or not.
What was the verbiage previously? Did we have one?
The black is what it read before, so it read about a 6-foot fence.
Is that what you're referring to, Pam?
Yeah, I mean, it said a pool must be completely surrounded by a fence or wall. If a fence is installed in the ground around the pool or yard, it must not be less than 6 feet in height, with no openings, gates or doors that can be fastened to protect against entry and cannot be chain link fences. That's what it read.
Do you have any idea how many private pools we have?
I know of one pool. We had one person had a pool. It didn't have a fence around it. They had a lot of other nuisance problems on the property. We told them they also needed to have a fence around their pool. They got mad, they reached out, complained. And so that's what brought this up. So all of this is because there's one pool in the county and one person didn't like the fact that I asked them to comply with the one regulation about pools.
Well, for full disclosure, I'm the one that they complained to. And I saw the 6-foot fence as it being an unnecessary
That's why
item. Sure, of course. And I think it's part of my job that if community members bring forth regulation that is overburdensome and policy for the sake of policy in and of itself, then we need to take a look at that. And that's why we're here.
I agree. I don't disagree that it should have been voted upon. It wasn't something that got looked at carefully because there wasn't anybody it was an issue with.
Yeah.
So that's why we have it covered, which is a simple.
And I know this wasn't just yours, the planning commission had their hand in this to do it.
They didn't make any changes. I mean, they didn't make any changes. They actually recommended the 6-foot fence instead of a 4-foot fence.
Well, I think private property is private property, and so in this case, I don't think it should, I'm not in favor of that part of it. I'm in favor of the utility part, but I'm not in favor of 3.2.5.2.
Well, most of the rest of it is covered by building code, and so, I mean, you don't need to leave, even the electrical code is covered. The state has to do electrical permits for anything people do, so you could just eliminate all of 3.2.5.2, and you wouldn't be creating a gap where it would be in danger because of building code requirements already to cover all of this.
So I have a further question. If we eliminate the 3.2.5.2, then does that revert back to the 6-foot high fence of the old way?
No, if you eliminate 3.2.5.2, that also eliminates the 6-foot fence. It eliminates all protections related to use, all rules related to use and land use. And then you're just dependent on the rules from there,
Right.
which has very few rules.
And Todd, if we were to just use the state's language, would that address public pools adequately?
Yeah, the 3.2.5.2, it says private pools. So public pools, such as like in hotels, again, common areas of apartment complexes have pools. There are state regulations that apply to those type of pools that are open access to residents and or to like the general public.
Okay.
And our land use code already has rules for a public pool.
I'm not aware that they do. I think it all comes from the state.
Just comes from the state.
Yeah. That's what I understand.
I would agree with that. Go away with the 3.2.5.2.
If you make that motion, I recommend you delete these 2 definitions as well. They have no purpose. There is a 3rd definition in section 11 in what I handed you, the personal utility. But you could eliminate the private pool and public pool definitions from 11. We don't need that if we're not going to.
Those are on the last page.
Yeah, on the last page.
So that's the 3rd definition.
You would keep the first one, delete the second 2, yeah.
And that would be deleted 2 and 3.
Yeah.
Are you going to take a stab at that, Ron?
I can. Mr. Chair, I move to adopt resolution 2022-70.
I'm sorry.
Oh, wait, I apologize.
Yeah, we haven't done the
Public
second part of the
comment.
resolution, yeah. Right. So we'll come back and do the motion. Okay, sorry. Okay, so the second piece is under section 326, which is accessory structures right now. Regulation reads that subparagraph 2 that is lined through on your example. Propane tanks shall be exempt from setbacks for accessory structures provided the tank location conforms to requirements of National Fire Protection Association, Colorado Department of Labor and Employment Division of Oil and Public Safety. So that is because propane tanks are not permanent structures, right? They're temporary or there, so we don't care if they're in the setback because they can be moved. In the case, as I mentioned, solar panels, that's not quite the same. So what we've defined here is personal utility structures. So personal utilities, as by the definition, is utility that's meant for just the owner, the use of the owner. The examples that are given are solar panels, propane tanks, on-site wastewater treatment systems, cisterns, etc., and they're subject to these requirements. So first, no part of a personal utility system or structure, neither underground nor above ground, either portable nor permanent, may encroach into utility, ditch, right-of-way, or access easements, right? Because those easements belong to somebody else, need to be available and clear for someone else's use above ground. B, permanent portions of a personal utility system or structure which are above ground must also meet property setbacks. So if you're putting up a solar panel on a post, that's a permanent structure and it needs to meet the setbacks. C, portable or temporary portions of a personal utility system or structure which are above ground shall be exempt from property setbacks. So again, utility, the tanks for a propane tank, for instance. D, on-site wastewater treatment systems must also meet setbacks from wells, cisterns, streams, rivers, wetlands, lakes, etc., as required by state regulations. So the regulations for health department have all kinds of rules about these items and whether you have your leach field near them or not near them, how far away you have to be from a cistern for a leach field and all that. So those rules are health department rules, and I just put that there to remind people they have to know what those are and follow them. And then the location of propane tanks must also conform to the requirements of the National Fire Protection Association and Colorado Department of Labor and Employment Division of Oil and Public Safety. That just replaces the additional requirements that were previously in place for currently, I guess, in place for the propane tanks. And then the definition specifically says personal utility is a system or structure that provides utility service, including but not limited to water, electricity, natural gas or propane, wastewater treatment, etc., predominantly for the personal use of the owner. And then method 2. And that's it. Questions about that?
No, thank you. Okay. We're ready. Applicant in this one.
Nope, no,
So, take public comment on that same kind of deal.
Yeah, it's a hearing, so you can take public comment in favor or against.
Okay. If there's any public comment, anybody in favor?
I think this is fine.
You got a phone? She'll share the podium with you if you got a phone.
Okay.
Sorry. Name and address.
Bill Hudson, 446 Mount Street, and just as an editor, I think the neither underground or above ground should be either rather than neither. This is a double negative, so both of those neithers should be neithers.
I'll correct that.
All right, anybody else? Hearing none, anybody opposed? Okay, nobody opposed, close the public comments. Commissioners have any additional comments?
No, sir, thank you.
Entertain a motion.
Mr. Chair, I move to adopt resolution 2022-70, amending the Archuleta County land use regulations with omitting 3.2.5.2 and retaining, I believe it's option 1, for public pools.
Just for clarity, I'm sorry.
That's all right, go ahead.
Because the definitions aren't numbered,
Right.
we just specify keeping the personal utility definition and striking the private pool, and public pool definitions.
Yes.
Okay.
I'll second.
There's a
Yeah, thank you for.
there's been a motion and a second. All those in favor? Aye.
Aye.
Motion carries.
Thank you, Matt.
Thank you. Okay, 202, we're going to adjourn land use regulation, public hearing and convene the liquor board. Raise your hand. Do we need to? That's consistent.
As for temperature.
Thank you.
So this is an application for a special events permit for the Pagosa Mountain Morning Rotary Club to sell malt beverages, spirits, liquor at the Archuleta County Fairgrounds, 344 Highway 84, Pagosa Springs, for the Archuleta County Fair on August 4th, 5th, 6th, and 7th, 2022. The sheriff has been notified of this event. Proper fees were collected and the premises was posted for the required 10 days prior to today's hearing. The financial impact to the county is being paid for the county fee schedule, and staff recommends approval of the special events permit.
Commissioners, have any questions?
No, sir, thank you.
Take a motion.
Mr. Chair, I move to approve a special events permit for Pagosa Mountain Morning Rotary Club for their event on August 4, 5, 6, 7, and 8, 2022 as presented.
Second.
A motion and a second. All those in favor?
Aye.
Motion carries. Liquor board consent.
Gentlemen, item I-8 under the consent agenda for the liquor board is consideration and approval of a beer and wine county license for renewal for Pirelli Natural Horsemanship.
Commissioners, have any questions?
No, sir.
Take a motion.
Mr. Chair, I move to approve the liquor board consent agenda as presented.
A second.
A motion and a second. All those in favor?
Aye.
Motion carries. Okay, adjourn the liquor board, reconvene the regular meeting at 2:04. On the consent agenda.
On the regular consent agenda today is the payable warrants and purchase cards for July 6, 2022 through July 19, 2022. The regular meeting minutes of July 5th, 2022. Item C, the consideration of resolution 2022-71 to consolidate 10 lots into one lot in Block 6 of Piedra Park subdivision number 2A owned by Mary Baker. Item D, consideration of resolution 2022-72 to consolidate 4 lots into one lot in Block 2 of Rio Blanco subdivision A owned by Herbert E. Robert. Item E, consideration of resolution 2022-73 to consolidate 2 lots into one lot in Loma Linda subdivision unit 4 owned by Barbara and William Remington. Item F, consideration of resolution 2022-74 to consolidate 2 lots into one lot in Pagosa Highlands Estates owned by Bruce E. Liss. And item G, ratification of the chairman's signature on a grant offer for the airport pavement maintenance.
Take a motion.
Mr. Chair, I move to approve the consent agenda as presented.
A second.
A motion and a second. All those in favor?
Aye.
Aye.
Yes.
Second. Motion.
I was reading.
On the new business. Second, Maez.
Have you listened, Pam, tonight?
Well, I mean, I'm not prepared to present because I was not where I was expecting.
It's okay. So, for you this afternoon, Commissioners, public hearing is a temporary moratorium on the submission of new vacation rental permits. As the county researches, develops for potential proposal to the board of new regulations on short-term vacation rentals as we define them here in Archuleta County. It is for a term of 6 months. Of course, that can be ended earlier by the board if they so wish, or can be extended if the board so wishes. Again, it only applies to new applications. It does not apply to current permits that have already been issued that are up for renewal. Those will continue to be processed under the moratorium. As well, there is also, as set forth in Exhibit A, there is an exception petition process. So if there is a property that's under contract for sale, the buyer who, if they intend to, or the reason they sought to buy the property was to use it as a short-term rental, there is a special exception petition process whereby they can petition Ms. Flowers to review it. And if that petition is approved, that they can move forward then with a vacation rental permit application. The details of that are set forth in Exhibit A. It applies to under 2A, any developer, person, or entity that either is A, under contract to purchase a dwelling unit prior to the date on which this resolution takes effect, or B, has received a building permit prior to the date on which this resolution took effect and achieved substantial construction of the dwelling unit, which will be defined as having passed the foundation inspection by the building department within 30 days after the resolution took effect. So those individuals are authorized to submit a special exception petition. They must be submitted within 30 days of this resolution being adopted. It is adopted by the board today. They're going to be 30 days from today. The required information is set forth in 4. Petition review is set forth in 5. And all the information is there within it. So that is basically a brief overview and summary of what is before the board this afternoon. Happy to entertain any questions that you may have.
I believe you addressed the question that I asked this morning, so thank you for doing that.
You're welcome.
And Todd, if a property is currently, a property owner is currently seeking a hearing, would they be within this exception if, let's say, they came out in favor? Would they be discluded in this instance?
Could you clarify? I'm not quite sure where. Go ahead.
So if a property were in the process of asking for a hearing for their property.
Like an appeal, you mean?
An appeal, yes.
Right. So if they already have a complete application in that has, say, if it was denied, they're appealing, that, so long as there's a complete application in that's in process prior to the date of the moratorium, that will continue to move forward.
Okay.
Yes.
Can I suggest that for the building permits, that the same be true if they've submitted their application and paid their fees, whether they have their permit or not, that will be considered an exception? Not that they've been issued a permit, because they could have submitted a permit 3 weeks ago and they're still waiting for their permit. I think if they've submitted the application and paid the fees, that would be considered a completed application, and that should apply under the building code section as well.
Yeah, anything, typically the exception when it comes to a moratorium, anything that's been submitted and deemed complete, the moratorium does not apply to that. Because the moratorium is to stop the application process. So the application is in and deemed complete, then it's not an application, it's in process.
Any other questions? Okay. Before we take any further, we're going to open it up to the public comments for anybody who submitted it. So the first one up will be Brian Wells. Representative will come out.
Thank you, Commissioners. Brian Wells. I own 217 Pinion Causeway, 3022 and 3021. My wife and I are primarily long-term rental investors. And I'd like to just kind of a little bit of the point, but say that I think there's a lot of things that short-term rentals bring very positive to this community, and I appreciate that you guys are taking the time to look at this one carefully. The short-term rentals brought me here, and since I've been here, I've been able to invest in the community. Like I mentioned, we own a long-term rental now and a short-term rental. I'm currently in escrow on my short-term rental to sell it. With the proceeds from that, I intend to buy 2 long-term rentals. So I'm very pleased to see this exception in place, because if it's not, I fear my sale would fall through, and the 2 long-term rentals I plan to purchase, the proceeds would not come about. A side point was, I've heard Ms. Flowers say before that you guys are looking at condos as one of the areas to focus on to fulfill the long-term rental shortage. I live in, like I said, I have places in the lodge condos. Of those 36 condos there that were all meant when they were built to be vacation homes. There's no garages, there's no storage in those places. There's not even enough parking in the parking lot if everybody was there at once. Of the 36 units that are there, 20 are owned by owners who only come and visit them a short time of the year. There's only 6 full-time residents there that own it. 3 long-term renters, one of them which are mine, and 6 of them are short-term rentals. So I guess my point being with that other comment is that I don't know if focusing on those condo developments as an area where we should get rid of all the short-term rentals is really going to have an effect. I think it's an ineffective place to have a focus on, to putting many long-term rentals in there. Thank you.
Next up, Lori Derek.
Good afternoon. Lori Harity, 380 West Gold Place. So I know a guy that sells a lot of real estate in Pagosa Springs. I consider him to be pretty brilliant. I think a lot of people don't realize. Ronnie, come on. I don't think they realize that my husband Mike has been selling real estate since he was 18 years old. And back in the summer, fall of 2020, through a bunch of meetings, and they'll be recorded in notes, that Mike said, this market will correct itself and we won't have these issues. We're here. The market is correcting itself. I'm gonna leave you these statistics so that you can take a look at them, but here is as of 8 a.m. this morning. There were 30 condos and townhomes available for sale in June. Last June there were 3. And I'll hand you this. In July, there were 30 condos and townhomes, and 4 were under contract. In July, there were 38 units, 7 were under contract, including the original 3 that hadn't closed. So 4 more units went under contract in 19 days, but 8 came on the market. So for every 1 unit that goes under contract, the inventory's been increasing by 50%. Given that most sales happen from May to October, it's not real easy to calculate the traditional realtor absorption rates, but today's math shows 6 to 18 month absorption rate of the condos on the market. It would be 10 months to eat up all these condos if not 1 more property came on the market. That's only the condos. I can do the houses too, but I don't want to take the time right now. If the interest rates stay at 6%, and it's likely they won't, this is just going to be the trend we're going to keep. This is the trend we're going to keep on. The real estate market is stabilizing and it's settling in a downward trend. This should be enough to allow the vacation rental market to do the same. I'm not in favor of a moratorium, surprise, but I'm one person. If you insist on punitive over business-driven decisions, then at a minimum, have the moratorium effective November 1st when the summer selling season is over, so you can allow
The elderly and aging out customers, as well as those who have health needs and need to sell right now during a downturning market, to have the opportunity to sell this summer. September is a very strong real estate sales market in Pagosa. Historically, after the kids return to school, the early retirees with stable incomes come to Pagosa to pursue their dreams, the same dreams that drove many of us here. There are many properties on the market right now that are people aging out and have health conditions. My neighbor is one of them. They need to relocate to help a 40-year-old daughter who has terminal cancer and has 10-year-old twins. Their home is priced at $560,000, 14% below existing comps, and we have been on the market over a month. I have another home listed on handicap, owned by an 82-year-old woman aging out and needing to relocate as well. This home is 18% below existing comps and has not had an offer. With weekly increasing inventory and price reductions, you penalize these types of sellers when you eliminate any buying pool out of Pagosa right now. Again, we won't need a moratorium come November, but at least allow the current sellers as much opportunity to take care of their health and needs for selling as possible. A 6-month moratorium would allow the stakeholder groups to, a 6-month moratorium would allow, I'm sorry, I had the wrong words here. Allow the stakeholder groups to formalize and have a voice in making Pagosa the type of community we hope to see moving forward. Bring in the data and the facts, not the punitive measures and subjective opinions, not based on scientific exploration. Here's your ADM breakdown.
Next up is Mike Carey.
I'm going to take my wife out to dinner. Mike Carey, 380 West Gulf Place. First, I wanted to thank the commissioners and thank Pamela for holding the 2 public meetings. I think that's been missing from the calculus from the start. We've had to show up at these meetings and try to fill the room with people that are given 3 minutes. And I would hope Pamela would have related, the dialogue was friendly. It didn't start out that way. But once we were allowed to speak and we felt we were being listened to, I think we came up with some creative ideas on helping to be part of the solution rather than being blamed as the sole part of the problem in the community. So again, I want to thank the commissioners for tapping the brakes, and I want to thank Pamela for putting on those 2 meetings and listening to some of the other stakeholders in the community. I as well don't like moratoriums. However, I appreciate the fact that you're willing to tap the brakes, put together a group which I would hope would include all the stakeholders to really look at the facts, do the analytics, look at what other communities are doing, and get reliable data to determine if what they're doing is working by the measurements that we want, by the objectives you've set relative to changing any regulations on short-term rentals. So for that reason, I'm going to be supportive of a moratorium with a couple of exceptions. I think your language, frankly, sucks. I think what's stated here is very prejudicial and lacks valid data to back it up. For example, when you say we're going to continue to experience substantial additional loss of housing stock to vacation rentals, who's made that determination and how? And I think when you put that in a resolution, you're prejudicing the community, again, and villainizing short-term rental owners. And I don't think it's necessary. I don't think it adds to the resolution, as well as statements about overcrowding and limiting the existing infrastructure to support visitors. Hey, bear in mind, COVID's over. There aren't as many people here, and the sales tax revenues and lodging tax revenue collections back that up as compared to last year. So last year was nuts, no question about it, but it's not as nuts this year. Now, we still have shortages of employees, but there aren't as many people in town, and the numbers bear that out in terms of sales tax and lodging tax collections. So the other statement in section 4, preserving the health, promote the prosperity. I don't see how a moratorium or more regulation promotes the prosperity of the community or improves the order and convenience. So if this language could be neutralized until you finish the study and you can make these kind of statements and they're backed with meaningful, valid data, I think, just say, we're going to do the moratorium so that we can study and make determinations as to the best path forward. Thank you. And again, I appreciate you tapping the brakes, and I appreciate what Pamela did to hold the meetings for the public.
Heather Simpson?
Hi, thank you. Heather Simpson, 145 Davis Cup Drive, Unit 4049. I just had a quick question about the, you actually answered my original question already, but, so if I have buyers who are closing on their condo on August 17th, and their intentions are short-term rent, will they have a special document or a certain document they have to fill out for an extra petition? How does that work?
I should be answered by me. They don't know. So really, if you look at Exhibit A, the moratorium, it spells out what needs to be contained in there. So if you basically do a cover letter and then provide the information under 4A, B, C, D, we have not enrolled form, but we could, and we can, take time to take a look at that. But that is really I don't want to delay, because of course, if it's adopted today, then there would be 30 days to submit something.
Okay, so that's the 30 days.
That is the 30 days from the date of the resolution adopting the moratorium. That's when the clock starts ticking for the 30 days. So 4A basically provides what you need to submit. They can put that together with a cover letter, and that says, basically a cover letter that's almost a form of an affidavit, which, a lot of cover real estate forms have affidavits that you can have a copy to put into this cover letter and have the client sign it. So long as they're under contract, they're good to go. They can file a petition for the exemption.
Okay, and then as long as the property basically follows all the short-term rental requirements, there would be no reason to just say, no, I'm sorry, I'm not giving you a permit.
Right, so the special exception permit, as long as if you meet the criteria for that gives you the ability to move forward to submit a new application for vacation rental.
Okay, perfect. Thank
Sure.
you.
You're welcome.
Bill Hudson?
Bill Hudson, 446 Loma Street. I am not here to represent Pagosa Housing Partners, although we have a deep interest in our housing situation here. And I am here representing Pagosa Daily Post, which is me. And I been writing about government decisions since 2004 for the Pagosa Daily Post. And I've seen some very poor government decisions made in our community. I just wanted to express to you that I think this commission has been doing their work well. I think you've been looking at things carefully and conscientiously, and I just want to let you know, as someone who's watched a lot of accidents and bad decisions in this community, I think you folks are doing a good job. So I want to thank you for that. I think this moratorium is one of the good ideas that you've come up with, because it's time to make some changes to the way that we're running our community. As you probably read, the report from New Policy that they wrote for Region 9 Economic Development, 40% of the STRs in Southwest Colorado are in Archuleta County. 40%. We have like 15% of the population and 40% of the STRs. And that was an accident. We have a community where 85% of the residences are out in the county. And county government isn't normally tasked with controlling population systems. Usually the towns and the cities do that. Counties don't normally have the mechanisms for having that control. But we're in an odd county. We didn't do anything when it was first happening, and so I'm very happy that you are putting this moratorium in place so we can really look at the problem and see what the best way forward is. So I thank you for that.
Charlie, Michelle. I said that right?
Just to let you know, for information purposes, we have about 50 properties with High Trip Vacations here that are live for vacation rentals. And we have lowered our prices this year compared to the last 2 years, basically between 30 and 40%. And I say that also from other property management companies here across the nation also. But rates have been lowered. People are not traveling as much with the coming recession and gas prices and all of that. Just wanted to give you that statistic for our company, 30% lower rates, and we still have 10% lower bookings than the past 2 years. So I just agree with what Mike Harity said in totality, but one thing is that COVID is over. People aren't traveling as much. Everything is slowing down for vacation rental purposes. And so thank you for considering that.
Thank you. Back on that.
Just a couple comments on 74 Whitaker Place. Thank you guys for listening. First thing I want to talk about Paul Hudson's comment of 40% of the STRs in Southwest Colorado are in our county. Well, the other counties have employers. They have businesses. They have a policy of having housing. You know, better planning years ago. We're a tourism county. So you just can't take that stat and just say, oh, this is a big problem. You got to look at the whole sum of it. Look at the other counties in Southwest Colorado. Look what they're doing. Do they have the deepest hot springs in the world? Do they have the national forest? No, they have businesses. They have ag businesses. That's what they do. It's different, you know? So just think about that. I also want to thank Mike and Lori Harity for the data and the facts, you know, about this resolution. I would ask, where is the emergency? You know, it's an emergency resolution. You know, where's the emergency? This county, the planning and the commissioners, you know, have already, they've already reduced the vacation rentals with the redirections, with the regulations, with a lot of things that are going through the permitting process where they're approved this year, the house is exactly the same, it's not approved now. I mean, there's already people selling those properties. So where's the emergency? You know, and it just feels like this vilification of tourism, leaving out data, not using facts and coming up with resolutions. It doesn't seem like that's a great way forward. I don't understand how that's anything more than what we've had in the past, and I'm looking for leadership from our commissioners, you know? I mean, I feel like you guys swore an oath to the people of this county. I feel like this resolution will hurt tourism, will hurt businesses, will hurt property owners, and it seems like a clear deviation of an oath to protect the people and property owners of this county. I would just ask you guys to take your time, really consider the rights you're stripping away from people that live here, people that own properties here, and the businesses. So those are my comments. I just hope you guys will understand and lean off of real facts and not create briefs and resolutions without it, especially if they're an emergency. Thanks.
Thank you. No further comments? Is there any comments or questions?
Well, I have some comments. I have to tell you that I'm also concerned about the needs of our county. And Mr. Knapp, that's some pretty strong language that you're using. And I would guess there's only a handful of people in this room that have sworn an oath to people they don't know forever. But not everybody's into real estate.
I'm not talking, I'm sorry that that's my job, but I'm not thinking about it. I'm not thinking about it.
Commissioner's talking.
Sorry.
I'm not trying to beat you up. All I'm saying is, I've received a lot of input from people on both sides and in the middle. And I agree with you. I think we should make this decision with all the information that we can get. And in fact, I sat in this very chair last year and I asked all people that were in attendance that day, please get together, form a committee, bring a resolution. And I didn't get one. So here we are, and I feel like I'm back in the same place, and I'm asking again, and if we approve this moratorium, now it's, no, I really mean it. I want some solutions. I want some data that's local, that shows us what the best decision is to make. I think that in general, many of us are talking the same language, but we're coming at this from a different position, a different perspective, a different profession, if you will. You know, and I'm trying to be very considerate of the opinions that I hear, and that's from the person that is picked up and moved because they cannot stand living in the neighborhood where they invested their life savings to live. That's also from the person that said, you know, I was drawn here, I've been coming here since I was a kid, I bought some property, and I finally was able to move to Pagosa Springs in Archuleta County. I have an STR, and I'm happy, and it's worrying me what is coming up to the county commissioners. So I really am trying to consider all of the input that I'm getting. And I certainly don't mean to speak on behalf of the other commissioners at all, but this is very important to me, that we make this decision and we make it right. This is not additional, this is a continuation from last year's discussion in the hopes that there would be people that got together and brought forward some solutions and suggestions. But when we didn't get it, I still want that same information. So this is where I'm looking at this from, because I want it to be Archuleta County specific and what the best decision we can make for us, all of us. Not just some of us, but those on either end of the extreme. So it's just important that you know that this is how I'm looking at it, and this is my position. Thank you, Mr. Chair.
You know, I totally agree with Mike Harry on this. The economy has always set the standard here. I've lived here all my life. I've seen it set the standard every time we have an influx, and then it decreases, then tons of houses go on the market, and then there's another buying frenzy on that side. But I think to what Warren was saying is, it's time for all the parties that are involved to get involved now. Let's come to the table. Mike and Laura have been at the table, but we haven't heard from a lot of the others. We just heard side comments or other roundabout comments through the Facebook or all that, but we need solutions. And we are going to be having a lot more of these discussions. We need to have them because we need to have some common ground where everybody is going to have to take a hit and everybody's going to have to give a hit. But we need to find the middle ground on this. Get as close as we can to this. Section 4 and 5, I'm willing to turn there on this. I don't think it's going to change the moratorium. But I've seen it before, many times in my lifetime. And it does set the standard, but we have a new economy, which short-term rental is part of the big growth factor in this economy for Archuleta County. We have no other industry here other than tourism. So what do? We all gotta come together, and we gotta have a reasonable solution. 6 months from now, hopefully we all come together so we can have a reasonable solution. I'm done, Mr. Chair.
Okay. May I make one more comment? I don't see short-term rentals as the cause of all issues. That's absolutely ridiculous in my opinion. There is a vast cause and effect that has taken place across the nation, maybe the world, I don't know. My world's pretty small, it's Archuleta County. But I think that's a terrible burden that has been placed upon the vacation rentals. And I don't agree with that, but it does have an effect. It just does. Everything we do has an effect. So I think it's important that I get that out there and that, again, you know what my perspective is on this. Thank you.
All right.
Thank you.
Thank you. Well, I think both commissioners made good points. And I think from my perspective, it's not, short-term rentals are the devil. They created all these issues. It's not. And nor is it, I don't think we need to get rid of them. But we need to find a happy medium. Both commissioners already said, who's protecting the rights of the people who bought here to retire and wanted the community. When they moved here, that's what they had. Now the rules have changed. And where are the rules that are protecting their rights as property owners? So I agree that short-term rentals have private property rights just as well. But the other people who moved here to retire, they raised their families here, they have those rights too. So that's all I'm trying to get out of this, is protection for both sides. And I haven't seen any so far for the residents. So just trying to find what's best for both parties, and hopefully we can,
So do it in November, it's a win-win. Let the seller sell, that need to get out of here.
We're not taking any more further public comment. That is closed. Please retain your own purse so we can remove from the room. Thank you very much.
Commissioner Dunn? More comments?
No, not on this topic, thank you.
Okay. Entertain a motion.
Ron, second the motion.
I'll let you take the lead on this one.
Okay. So, Mr. Chair, I would move to adopt Resolution 2022-71. 75, was it B, so it'd be 34. 75, setting a 6-month moratorium on new vacation rental permit applications and make that effective September 1. I think that would give the time, in my opinion.
Is there a second?
Mr. Chair, I do want to address section 4 and 5.
Read the that we're at.
Yes.
Do you have policy striking those from the resolution?
So here's my concern. I'm not, and maybe this is a question for Mr. Weaver. I know in some documents there is there's certain language that is required, although I'm not in favor of the inflammatory verbiage that Mike's pointed out. And I would ask Todd if that is, would this be as defendable?
No, it would not be. For example, the moratorium was challenged in court. This would not be as defensible without section 4 and 5. That's the whole purpose of that being in there, and the whole purpose of the moratorium. The problem with it, I explained, Mr. Khan, I'm sorry, about delaying the moratorium. Of course, that's completely up to you. The problem with that is that you're going to have an impending rush on the Flowers Department. They can't process applications and drafting regulations at the same time. So that's the reason for the moratorium, is to allow them to be able to focus on bringing regulations before you for consideration, and that allows them that breathing room. And really, the moratorium is for to preserve the status quo for those who have short-term rentals. It's not going to impact them at all.
So the emergency's on.
The emergency is on the rush to meet the regulations, and that will overwhelm the department. We're not going to focus on new regulations. So they're going to have to process applications.
Yeah, if you can't be quiet, then you can go outside and have your conversation, okay?
So that's the whole purpose of the moratorium, is to preserve the status quo. That's my comments.
Does that answer your question?
I don't like it, but it does.
Okay. All right.
And I think I'm looking at this from a business owner's position. If I have deals that are in the works, I think that was a fair and valid point that Cory brought up, although I understand that Pam's likely to have to be bum rushed, if you will.
She's gonna be.
With these. I still think that there are expectations when you were making a transaction that it would be harmful if we were to say this is valid, whatever, 1st of August.
Could you simply amend Exhibit A to say that if you're under contract by September 1st, you would have the opportunity to apply?
Yes.
I mean, then the moratorium could be in effect now for all the other circumstances, but if someone goes under contract to buy a home between now and September, if that's the date you're picking, then that would be allowed as an exception. You see what I'm saying?
Say that one more time.
The way it reads right now, effective right now, if you voted in as it's written,
Yeah.
anybody who's not under contract right now will not be allowed a special exception. So instead, amend the special exception date of consideration to be September 1st. And then the moratorium can go in place for all other circumstances, but it would just be the circumstances in which a real estate or a building transaction occurs before September 1st. So that would protect the businesses as you suggested.
I think that would get the intended result. Okay. Why not? Mr. Chair, I move to adopt resolution 2022-75, setting a 6-month moratorium on new vacation rental permit applications, amending the special exemption date to September 1, and the current resolution taking effect August 1, 2022. Like today?
I think that's what it's, the verbiage is.
Is it today?
Yes, sir.
I'm sorry, Mr. Wood.
The moratorium would take effect today.
Yes.
But we just extended under contract by September.
Yeah, so the moratorium is, based on how it's drafted right now, moratorium, if approved, goes into effect today. So what is on the table is the ability to apply for a special exception petition. If you're under contract by September 1st, you qualify to apply for that. Or also, there's that B, which is about building permit, and I have achieved foundation. So that all will be qualified to be, instead of 30 days from today, by September 1st.
I would amend my motion to include effective date today, which is July 19, 2022. Sorry?
Does that mean you're not extending
That's what I'm understanding.
Can I ask the question? I'm so sorry, but what if someone closed like 2 years ago?
Hold on.
Then they would be exempt. I mean, they wouldn't be part of that. That's the problem.
You know what I really don't like? And I'm talking to staff. I really don't like the fact that we're making sausage and butter. And the other part is we're trying to help you guys out too. But, you know, on game day, that's when everybody wants to help. And prior to this, we had a year, like Warren said.
You did.
And now we're just beating the hell out of this.
So, just to answer the comment, so if the September 1st applies, if you are under contract, you don't have to close, under contract, fully executed purchase and sale agreement. If you have that prior to September 1st, you can apply for the special exception.
I second the motion.
Okay. Got a motion and a second. All those in favor?
Aye.
Motion carries.
What she's saying is anyone that just closed then can get a permit, is that right? Anyone that just closed, like this week?
They can still apply for the exception.
Yes, if the deal has closed, right,
Good.
you're good.
So that it's going to include people under contract and people who have closed between now and September 1st.
Yes.
That's my understanding, yes, ma'am.
Because
That's the way I'm understanding it.
Are we clear on that? Because
it's really important.
that's really important.
Okay, yeah, I think we'll need to clarify that and then amend the motion because it is typically, right, so it's drafted if you're under contract on the day.
Right. But that's.
Moratorium goes into effect. So if you want to include those that have closed by September 1st, it will need to be amended to
Under contract
include that
closed by
clause.
September 1st.
Right.
Can we not resolve this whole issue making it effect September 1?
Right.
That's right.
Yes.
That's, yeah, so the moratorium
Yes.
would start September 1st, that's the way
Yes.
that it's
I
doing.
withdraw my second, so you can read that motion.
Okay, Mr. Chair, this is my final and best offer. I move to adopt resolution 2022-75, setting a 6-month moratorium on new vacation rental permit applications as of September 1, 2022, amending the special exception date, or actually, the exception date's this.
Yeah, you would need to amend the exception date because you're delaying moratorium September 1st.
September 1.
That was second.
All right, that was a motion and a second again. All those in favor?
Aye. Can I make one comment real quick?
Motion carries. Go ahead.
I would like to see a committee formed, no more than 15 people, one representative from each profession. And I would like to have a county, a county staff on that. So I'm throwing it out there. STR user or vacation rental user, vacation rental neighbor, a vacation rental owner, commercial lodging owner, realtor, STR business manager owner, property manager, thank you, tourism board member, workforce or low-income housing representative, and potentially an at-large. We need to get people's hind ends in a chair and have these conversations. We have 6 months, ready to go.
Put me in, coach.
Let's get a sign-up sheet.
No offense, but I'm not the smartest guy in town.
Okay, then take more time at home for me alone.
Oh, yeah, we're up to item B. Consideration of approval of letter support for outside services for yeah.
So, yes, this letter is, yes, sir, Colorado Broadband Office provides the Board of County Commissioners support for regional collaborations to apply to the middle mile broadband and infrastructure program and capital project funds to help provide more broadband service to residents in Southwest Colorado.
Commissioners have any questions?
No, sir.
I have none. Entertained a motion.
Chair, I move to approve the letter of support for the broadband internet grant application.
Second.
A motion and a second, all those in favor?
Aye.
Aye. Motion carries. Item C, consideration of approval of 11 applications for treasurer's deed.
Yeah, so turn the microphone on, help. So this, again, as presented a couple months ago, I think it was the date, we are doing a phased approach to applying for treasurer's deeds for properties that the county has certificate of purchase on through tax sales. And so these are an additional 11 applications for properties we're trying to do where they're generally in, only these are mostly in the Pagosa Trails area. And so this is the first step to apply for the treasurer's deeds, and then once this process is over, the next step is quiet title, and the third step, of course, will be to sell them off at a public auction.
Commissioners have any questions, comments?
No, sir. Other than, is this about what we should expect to see kind of every grouping, something towards this number?
Yeah, probably. I mean, I think we try to balance it out and try to group them kind of more of a priority from the attractive ones that are ready to go, put those up front, and then kind of stagger them down from there. So, yeah, I'm not sure how many more phases we may have.
The fifth phase is kind of just all the rest of them. And I want to say there's probably 20 to 25. I might suggest that we spread it out with 2 different phases just to ease up on the treasurer's office, the workload that they have to do with this.
Exactly. That's another reason why we're phasing it, is not just for it's also for the treasurer's workload as well. So, and then we could definitely divide the last 2 into additional 2 phases for those reasons. Okay. Thank you.
Any other questions, comments?
Are there deed restrictions on this?
Right now, we're just applying for the treasurer's deeds. When we get to putting them up for public auction, that's when we will notify the public of the deed restrictions that will be placed on them. So at that point, we will have deeds to the property, we can deed restrict them as we see fit. Or some may be good candidates to put deed restrictions, some we may not want to, but we'll bring that before the board prior to putting up the public auction.
All right, thank you. Good, nothing further, I entertain a motion. Mr. Chair, I move to approve 11 separate applications for treasurer's deeds as presented.
Second.
A motion and a second, all those in favor? Aye.
Aye.
Motion carries. If there's no further business for the board, we adjourn the meeting at 2:52.
Thank you.